Hello and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Gehringer. I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics at the University of Maryland. And I want to wish everyone a happy new year as we move into 2020 and get the podcast started off with new episodes. We have a few coming up that I'm sure each of you have dealt with some of these issues on your farm in some way or another. This one we're going to start off with today is looking at a case out of Maryland, looking at a workers' comp case involving a poultry farm manager, an integrator, and the farm owner. I previously put up some blog posts on this, so those will be down in the show notes. But now that we're back, we'll get started with our first episode of 2020. And kick things off with, this very important case. So let's talk a little bit about what happened in this case and give a little bit of an intro to set the stage for what we're going to talk about. In November, the Court of Special Appeals of Maryland, in Uninsured Employers Fund versus Tyson Farms, agreed with the Workers' Compensation Commission that a poultry farm manager's occupational disease disablement arose from his co-employment to both the poultry farm owner and the poultry company, in this case, Tyson Farms, Inc. Tyson's, at this point, may still appeal this. This may have happened over the course of these first few weeks of January, end of December. This is being recorded late in December. So we have something ready to go out at the first of the year. So if it is, I will update the show notes to make people aware of what has happened. But at this point, this decision could have implications to both growers and the companies that people need to be aware of. We'll talk a little bit about the facts of the case as to what led to this. This poultry farm manager was hired to work on a poultry farm in Worcester County, Maryland in 2009 that grows chickens for Tyson's. At the time, the farm was owned by Mr. Ung, and the poultry farm manager was hired to assist the owner in the operation. The owner passed away in late 2009, and Tyson's representatives trained the poultry farm manager how to maintain the farm and raise chickens since the owner's widow was unfamiliar with such practices. In 2013, she sold the farm to another owner who lived in Northern Virginia, and Tyson's would only agree to continue the relationship with the farm if the new owner kept the poultry manager on the farm. If we look at the terms of the poultry production contract, under those terms, Tyson's retained ownership of the birds, provided feed and medications, determined how long the flocks were on the farm, and provided veterinary services and technical advice. Normal things we would see in most poultry production contracts. The contract included various addendums setting out detailed instructions on how to raise poultry on the farm. Tyson's continually provided oversight to ensure the operation of the poultry farm in compliance with the contract. The poultry manager lived on the farm and frequently met with Tyson's reps directly about adjustments during the flock cycles. After suffering from an occupational disease disability, the poultry farm manager filed a claim against his employer, the poultry farm owner, and the Uninsured Employers Fund became a party to the lawsuit because the employer did not have workers' compensation insurance. The poultry farm manager and the Uninsured Employers Fund then brought Tyson Farms, Inc. into the claim. After a hearing, the Workers' Compensation Commission ruled that the poultry farm manager's injuries arose from his employment on the farm and that both the poultry farm owner and Tyson's were his co-employers. Tyson's appealed the decision to the circuit court in Worcester County. On appeal, a 2-day jury trial was held with the sole issue of whether the poultry farm manager was a co-employed by Tyson. The jury returned with a verdict that Tyson was not a co-employer of the poultry farm manager. The Uninsured Employers Fund appealed the decision to the Court of Special Appeals. And that brings us to the decision before the Court of Special Appeal, or that the Court of Special Appeals just issued from 3 justices. On appeal, the court was presented with the question of whether the evidence established that Tyson's asserted sufficient control over the poultry manager's job performance to make Tyson his employer as a matter of law. To answer this question, the court looked at 5 criteria to establish whether the employer-employee relationship existed. The 5 factors included the power to select and hire the employee, 2, the payment of wages, 3, the power to discharge, 4, the power to control the employee's conduct, 5, whether the work was part of the regular business of the employer. In prior decisions, the factor of control was considered the most critical factor in the decision process. Looking at Tyson's control over the poultry manager, the court thought this was more than enough to establish an employment relationship. The court points to the poultry production contract that we talked about earlier with the current farm owner, which required the poultry farm manager to be on the farm 24 hours a day, 7 days a week, and to manage the operation. The contract with the owner could be terminated if the poultry farm manager did not comply with the terms of the contract. The court also pointed to the addendums laying out how the flock should be grown to highlight the control that Tyson had over the farm. Prior decisions supported this outcome as well. According to the court, it looked like Tyson's asserted enough control over the poultry manager's job to be considered a co-employer. Tyson could direct him to complete tasks on the farm and could alter his performance to comply with the terms of the contract. The court pointed out that Tyson's did not have the expressed ability to fire the poultry farm manager, but did have the power to terminate the contract with the owner if the poultry farm manager did not comply with the terms of the contract. Based on this, the court reversed the decision of the circuit court judge. One justice in this decision dissented. This dissenting justice argued that the majority misapplied the prior decisions cited by the other justices. And based on those decisions and the following evidence from the trial court, 1, Tyson's never selected or hired the poultry farm manager. 2, the current owner of the farm set and paid the poultry manager's wages. 3, Tyson's could not fire the poultry farm manager. 4, Tyson's could not set the poultry farm manager's hours. And 5, Tyson's communicated directly with the owner on changes in practices to raise the chickens. At the same time, the current owner had authorized the poultry farm manager to act on his behalf in operating the farm. It would be easy based on this information to think that when Tyson's interacted with the poultry farm manager, they were interacting with the farm owner's agent, not a Tyson employee. Based on these factors, the dissenting justice would have affirmed the lower court's decision. So, as I do often in these, why do we care? Well, first, I need to point out again, this decision could still be appealed, and I would expect it to be appealed to the Court of Appeals. And this may not be the last decision we hear on this issue, especially involving this case. Based on the current decision, we have only one time where a court in Maryland has established that an employer of a poultry grower was a co-employee of the poultry farm. This current decision might be based on the fact that we had an absentee owner and an on-site farm manager who took care of the farm in place of the owner. It's unclear if this had been an employer of a poultry farmer not acting as the farmer's agent, and the outcome would have been the same. The dissent in this case highlights several issues the majority did not expressly deal with in their opinion. The majority never explicitly handled the point that the poultry farm manager appears from the facts to be acting as the poultry agents, the owner's agents with Tyson's. We'll have to watch to see if Tyson appeals this decision. Thank you again for listening to today's podcast. If you have any questions, please email me at lgoering@umd.edu, or you can tweet me at @AguilarPaul. You can also follow me on Instagram at the same handle. Thank you again for listening, and enjoy the rest of your day.